what has happened is that judges have, by their own interpretations, skewed the process of international commercial arbitration. In order to have a destination, an investment destination, you also need dispute resolution, because if your disputes are going to take 10 years to resolve, nobody wants to come in a territory where cases don't get disposed of fast. So an alternate dispute mechanism, which could be mediation, conciliation and arbitration, is vital to any system. We are a member of the New York Convention, which really sort of gives the reciprocity among arbitrating countries, and you have to have a reciprocating territory notification. So if an award is given from a reciprocating territory, it can be enforced even if it's a foreign award in India. And there are a list of territories which are notified. It's not a universal position. Only notified territories between India and a foreign country have the ability of enforcement. So when you look at all these constraints and the way the courts interpret, they bring in domestic principles into international arbitration. They bring in the principle that appointment of arbitrators, a judicial principle, so it can go up in further appeals in the system. They look at issues in terms of doing ad hoc arbitration instead of institutional arbitration. All these have had a deterrent effect, and that's why most arbitrations which are international arbitration law are done outside India, whether it's Singapore, whether it's London, whether it's Paris, any jurisdiction. They don't prefer to do it in India because our courts tend to interfere in processes. The general norm in international arbitration is hands-off. Let the arbitrators decide. The only time actually courts interfere is preservation of property. The subject matter of the dispute is normally preserved so that in the time that the arbitration takes, the property is not lost. Then effectively you're done on arbitration for nothing. The property is going to be destroyed or dissipated. Then why did you do the arbitration? Why did you spend so much money to do it? So courts tend to protect the subject matter of disputes. Specific powers are given to court to aid the arbitration. So that's where again the conflict was. They were using domestic principles of interference to protect or preserve the property. Now the law will move to even helping international arbitrations in foreign jurisdictions. Supposing the property is located, one of the defendants has properties located in a foreign territory. Courts give the benefit of protecting, because the jurisdiction of courts gets decided on the seat of arbitration. Wherever your arbitration is really placed, it is that court which really aids the arbitration. So these were some of the anomalies which were really plaguing the Indian system, and those have now been brought to the notice of the government. The government has had extensive public hearings. So they sort of went around India, had public debate on the consequences of these 5 or 6 judgments which the court has given. They went to Singapore and had a hearing. Then they had a roundtable meeting with law firms and the law officers in Delhi. And they've drafted what changes need to make. As I said, unfortunately, because the government has its own crisis every time and the parliament doesn't sit, this matter has not come up for this. No, they are not scrapping it. They are limiting it to certain very significant points. So patent and serious illegality, which has a serious, substantial injustice to parties, and public policy, which was another big problem for foreigners coming here. You can interpret public policy the way you like. So how will we get comfort that this is the good ground? So they are now limiting it to fundamental policy of India. Issues in relation to against the interests of, so if government is a partner, it's not a sovereign function. If it's a sovereign function, it's not arbitrable. It's only commercial disputes that really can. But again, they have that leeway here. And the third is, of course, if it's against public morality or decency. These are 3 grounds. So many grounds are available. They cut it down to these 3. No, I think they put in stringent conditions that it's not just the front end that you can participate in. Today they were only at the back end, but the back end could be of any amount. So therefore, if you want to set up a simple majority multi-brand retail company, then you can't do it by just a small amount of money. You have to put serious money into India. And once that serious money is put at the back end, you really help the logistics, you help the inflationary pressures, because you then buy in bulk, you sort of aid the farmer, certainty of supply, which today is being lost because the intermediaries are really making all that kind of money. If the wholesaler is dealing directly with the small farmer and really picking up bulk and with the certainty, then clearly price is also firm. The farmer doesn't lose things in wastage. So it has benefits. And if you look at the facts, the curious facts which have actually come out are that the small retailer is going to be, the bulk sellers which are Indian today, whether it's a big bazaar or whether it's a thing, and he's actually buying in bulk and making profit. He's buying at a less cost and in his retail store because he's giving the convenience of being in the locality. You buy your vegetables off the feriwala in the morning. You don't go to a big bazaar every day. So those kind of benefits is the same theory of going to the mandi in the past, that you go and pick up, the retailer goes and picks up stuff from the mandi and then comes and sells it on your door. I think that concept is even working today in the hypermarket, supermarket of the Indian promoted companies. So I feel that the same concept is not that the small retailer is going to be wiped out, because Indians still have the habit of buying daily. They don't go and buy fortnightly supplies, except for pulses and more long-lasting kind of products. Those they'll pick up in bulk, but the daily food stuff, nobody's going to go to a supermarket. As part of the phase 2 form 2, a lot more data is required to be filed, unlike form 1 or form 3. And one of the data which was sort of contemplated was, sort of contemporaneous other materials which will have a bearing on understanding the adverse effect of competition. And at the time when the draft was disclosed in March of 2011, they had contemplated legal invariance report. Now, normally between an attorney and a client in the Indian context, there is a privilege. So what we exchange with our client is not subject matter of filing. So most of us object to saying that we don't want our reports to become the subject matter of filing. This is a part of privilege. We're not waiving our privilege. So they sort of said, okay, fine, because in our due diligence report, we owe a duty to point out issues which could be of concern or grave. Finally, recognizing that, they sort of said, okay, the due diligence report does not need to be filed. But what's happening on August 18th in US might reopen this whole question. Because if they say that a regulator in the world is looking at that and the attorney-client privilege equally applies in US, it's not only an Indian context, why should we not file? I have a feeling it might be reopened. Okay. What happens is that a takeover court process, if you do it in sequence, would finish by 120 days.
Okay.
Whereas if you go into a phase 2 inquiry, the statute itself says 210 days. And there could be many instances because of lack of information or lack of complete information, it would stop the clock. So 210 might become 250, might become 300, might become a year or maybe more. It depends on what data is incomplete. Now, you have completed the public offer, but you can't really acquire the shares because your pending CCI. So the property of the public is locked in. You can't take control of that company. Offer is on. So there has to be a synchronization. If the takeover code is 120 days, the CCI must finish in 120 days. You can't have a mismatch. That's why US has 60 days. But the difficulty in India is that there is no data publicly available of products and regions and market information. Because nobody has really collated that information. There is no single company in India which can tell you, okay, this is your market share, or this is your market share in this region. So the inadequacy of the data will require surveys and specific information being collected from local markets. So there is a process where there is a inherent gap of data. That is one thing. Secondly, your interest runs. If you have bought shares and you don't have the CCI approval, you still owe the purchasers or the sellers 15% interest on that money. So your budget might be blown completely because of the CCI delay. And I think these are unfair because it's not really because of the applicant failing or the acquirer failing. It is because of the regulatory process that the whole thing has got delayed. Why should the regulatory delay be burdened onto the acquirer? This is where probably the suspension of interest must be made the norm. You can't be loading interest element on the buyer, So that's not fair.
So is there a step to kind of rectify
So
this?
there is another issue which is a problem in the takeover code and the CCI. The CCI has a power to modify a company. So supposing you acquire a company which is 3 undertakings and you've got 2 more and 5 is monopolistic or 5 is adverse. It has an effect on company. The CCI can say sell off one. Now if you sell off one of the target company, the price that you paid is inclusive of 3 and you suddenly tell them now it's 2. And that's unfair again. So this is a situation where the UK takeover code has actually contemplated that if you go into phase 2 and there is a remedy prescribed, then you actually suspend the takeover offer the moment you get into phase 2. You don't go with the offer, you postpone the offer, you reset the offer if the combination is cancelled. If the combination is abandoned, then there is no public offer. So these are the kind of situations where in common sense business, the regulator has actually stepped in and prevented injury.
Okay.
Our regulator must think the same way. This is not tackled today. See, there is a dearth of independent directors, and all said and done, whilst the previous chairman of SEBI has said, you tell me I'll get you 1,000 people. But in fact, there are no such 1,000. You have got that quality of standards that you need. So it is a strain on independent directors because they come from their own disciplines. You know, I may come as a lawyer, I know the law, I don't know business or I don't know strategy, I don't know. So many things are not within my domain now. Somebody may be an accountant, somebody may be a management expert. Everybody doesn't know everything. The responsibility of management is different from the responsibility of people who are coming with their skill set. Now you can hold a person responsible for his skill set because he's generally responsible. If I do a bad job as a lawyer, I am liable for my bad job. But I am not liable for a bad job of an accountant. What is happening is by virtue of the extended principles of duties and responsibilities, every duty must have a corresponding obligation. Now, if the obligation is a liability, why would I as an independent director, what am I getting? Guarantees. Or some companies may give commission, some companies don't give commission. But it's completely mismatched. My liability is much more than my compensation. And if that is the case, why would I go on a board? Why would I would say, I don't want independent director. So it might be counterproductive to put so much responsibility on an independent director which is not commensurate with his compensation. So that is an area of focus which I don't think the MCA has looked at with criticality that it needs. When you over-regulate or over-prescribe, it has an effect on people because if a question is asked of me, I'll say I want to be responsible for areas which are my expertise. Why should I be liable for something else? And don't hold me responsible for everything on this principle of neglect. It's a very nebulous principle. What is neglect? So, it's getting into more and more liabilities for directors, and that's sort of sometimes counterproductive. You might have a supervisory board, you might have to, government may need to think differently. You have to have people who really add the supervisory knowledge, and then you have to have an operative board. It should be just operating people at the executive.